committee in discussion today. So on today's agenda, we have got 2 matters broadly, but 3 more specifically. The first is the Road Accident Fund. I have shared with the members a memo, which I will talk to at some detail. Secondly, we are going to approve the oversight reports. We're going to review the oversight reports and then take any proposed amendments and then finalize. In the case of the oversight reports, what we will do is we will take the comments of the members, and then once those have been effected, we will once more share them with the members and give about 2 days or so for everyone to review and be happy that the version that goes to the House is a version that everybody has seen. We've learned some lessons from the budget process. So we have to make sure that everybody gets to specifically say that they are happy with the content and there are no issues when we get there. So, sorry. Honorable Skosan.
Thank you, Chair. And good morning to all the colleagues and staff members. I just wanted to find out, because normally we have people here who we don't know. So when it comes to staff members, people who are sitting at our back, who are they? Because I know some of them, I don't know them. Thank you, Chair.
So we have the usual staff members, Honorable Skosana, that I'm hoping that you know them. What typically happens in committee meetings, you also have members from the Parliament Monitoring Group. And those are the people that take detailed notes of the meetings and so on, and then they post them on for the public to see. And then all committee meetings are also open to the public, and members of the public can come and sit. We do not ask members of the public to introduce themselves because they are not participating in the proceedings.
My follow-up question, Chair. You know why I'm asking that? In one of the meetings in this core committee, when we were out there, some of these people who are sitting here, some of them, I'm not casting aspersion in anyone. They approach us and say, why are we too radical in our questions? Hence, I'm asking that. To say that when we're talking about the issue of RAF here, 2 gentlemen approached me here and say, but why are you saying people should have a friendly, lawyers must be the one who are dealing with this issue? And I was very offended, Chair. Hence, I'm asking. It's a deliberate question.
Yeah.
And please, Chair, only
my hand was up first, Chair, so I don't know why he's getting a second speaking opportunity.
No, it's a follow-up question. The Chair will answer. So, I don't need to.
Colleagues, can we
try to be defensive? The Chair is here to chair the meeting.
Honorable Skosana, we are too early in the meeting.
Thank you.
And Honorable Beck, please. So I've heard you have taken your point. I'm now going to take the comment from Honorable Beck, and then I will make a final determination and we move.
Chair, it's I'm sorry that the colleague was offended that people approach him, but I'm afraid to inform him that we are all public representatives and you might very well be approached. This is an open meeting, it's not a closed meeting. The question is entirely inappropriate as to who's sitting in the back. Whoever wants to sit in the back, who's been given access to Parliament, can sit in the back. Let's proceed with the meeting.
Okay. Colleagues, can I just make a final determination on this? Okay. We have in the room honorable members of the committee. We have in the room the members of the secretariat. We all know them, they need no introduction. From time to time, in fact, almost at all meetings, we have people from the Parliament Monitoring Group. They work with Parliament. They perform an important public service. We have never asked them to introduce themselves, and those people change from time to time. We also have in the meetings representatives of members of the executive who are here to take notes on their behalf because the proceedings pertain to a particular department. For instance, I have come to know some of them. We never ask them to introduce themselves. Everyone else, I assume they're either members of the public, they are an interested party, they are a journalist, they are a member of an NPO or whatever the case is. We never ask them to introduce themselves. They sit in the meeting and the meeting proceeds. If, Honorable Skosana, there is someone who you believe has said something that is inappropriate, either in the proceedings or outside of the proceedings, that would need us to raise it with Parliament, in that they've threatened someone or that sort of thing, that we can take up. But what we cannot start doing is asking members of the public and other interested parties to introduce themselves. Parliament has never done that. So can we please move on? Unless there is something that you are feeling threatened, you cannot proceed with the meeting because of that, then sure. But otherwise, I don't see why we need to do that. Honorable Madlala.
Thank you, Chair. I concur with you that we need to proceed. I think as a matter of principle, though, what we may want to address going forward is the accreditation process. We understand that there's a process of Parliament. It's a public meeting, but I don't know. I've got my member of Parliament card. I'm known who I'm. I don't think that we need to have people introducing themselves per se, but in future we can't, as a committee, have people without tags. And let's say maybe they become 30. Who controls that? I'm trying to understand. Now there is a discussion. It needs to be controlled in a manner that everyone is comforted to say, okay, this is media, they've got a tag, they've got access, this is so and so. They don't need to introduce themselves. We are members of Parliament who are known, this is where we sit. Everyone knows who we are. They don't even need to ask us. I'm thinking that there may be some clarity needed along those lines. Thank you.
Thank you, Honorable Madlala. So the process is, and I've been a visitor to Parliament numerous times, and I've also seen this process works. There is a visitors center, which is the other entrance, which is on the side of Good Hope Center. Everybody that comes into the precinct, whether they're going to an office or they're going to a meeting, presents themselves there, they are searched, they say why they're here, and they are given a pass. The pass they get, unfortunately, does not have a lanyard. It's a piece of paper. When they get to the bottom where we swipe, they present this pass and they once again scan their belongings, as we all do when we enter the meeting. My belief is anybody who makes it up to this point has gone through that process. That is what government officials have to do. That's what everybody who comes to the committee has to do. If your suggestion is that we say to Parliament, everybody should then get a lanyard, we can have that conversation with Parliament facilities, but there are two checkpoints. Nobody can enter this building unless they are a member, they work in Parliament, or they've been given a pass by security, and downstairs they've got to produce it. Once we are here, my assumption is all of those protocols have been enforced. And so I don't know if then we must ask people once again to create another security checkpoint. I don't think it's appropriate for the committee to do that. But that's a process. So everybody who's here has stated their business, why they're here. So members, can we proceed? I honestly, can we please proceed, members? Please. What's important is that to the extent that there is, I haven't experienced anyone. The only time there was a disruption here is when new members of the PMG group walked behind me right here. And it was their first time and they were very apologetic. Beyond that, we have not had a disruption in the meeting. So please, members, can we please proceed with the meeting? I don't want us to get distracted by an ancillary issue like this, please.
Because I started this thing myself. And for a reason. And for me, no one is going to intimidate me. We can start the meeting, but what I don't like, if someone comes in because he doesn't know or he wants to protect someone he doesn't know about. I'm saying about my experience here. I'm talking about my experience. It doesn't matter whether they can come 100 of them here, but I'm saying they must stop. When we are out of this meeting, to discuss issues which we discussed here. Because this where we are,
meeting. Because you are not going to keep speaking when we are speaking. You say, Chair, we do have the capacity.
Colleagues, no,
We do have the capacity to be arrogant. We won't tolerate
colleagues.
We
arrogance.
won't tolerate him, Chair.
Colleagues, can I?
This young boy thinks he's going to speak anytime he wants when we are speaking.
Parliament won't do
Honorable Beck, Honorable
outside if you want to.
colleagues, please, can you please switch off your mics, please?
Yeah, we are racist, yes.
No, colleagues, can you please switch off your mics, please, members. Members, we can spend the next hour debating ancillary issues, or we can get on with the business of the meeting. Can I appeal to you? The reason I said once I speak we're going to proceed in this way is because I know this meeting we can spend the next hour or so now discussing ancillary issues, okay? The only thing I'm going to ask members is that we respect one another. When another member has the floor, we allow that member to finish speaking, however strongly we feel about what they're saying. Yes. And Honorable Beck, I have to say that you have spoken over a member while they're speaking.
Chair, he called me a racist. He pointed his finger
No,
at me.
no,
You're
no.
addressing me.
So colleagues, come on. Colleagues, we have to make a decision here, okay? So we have to make a decision here about proposing. Okay, so Honorable Skosana, may I also say to you, because this is going to take us down a rabbit hole of what is parliamentary to say and what is not. Let us not get into that territory. May I please, you might feel strongly about Honorable Beck's behavior, but when you say he's being racist, it takes us down that rabbit hole. May I please ask you to withdraw that specific comment?
No, I'm not going to.
So,
He said it himself as well.
what did he say?
I said I'm a racist.
That's what he said, yes.
Okay, may I then propose that if Honorable Beck wants to take the matter up in terms of the rules? No, sure, I am chairing the committee. No, hang on. I'm going to come to you, Honorable Ment and Honorable Beasley, okay, and Honorable Skosana. I'm going to come to you. But all I'm saying is that I expect when we get here as members to focus on the business at hand, to recognize that we've got differences over various issues, but the most important thing is maintaining the decorum of the meeting. We don't interrupt each other, we don't call each other names. That's very important. And the reason I was suggesting to Honorable Skosana, and I can't force you to do it, that you withdraw that comment, is so that we can move on. There are no mutual complaints that go up the rules and up the chain, and we've got to make rulings, because I would like us to proceed with the meeting and our proceedings in terms of the way that we have before. I'm not protecting anyone. But what can happen in this meeting is that we can then spend the next hour or two discussing technicalities and who said what to whom and so on. And I don't think that is appropriate, given the importance of the issues at hand. Can't prevent you from speaking, so I'm suggesting that we please move on. But if members feel that you need to still make your comments, then let me know. But can we please proceed? So Honorable Mentor, you had your hand up, then it was Honorable Beasley, then it was Honorable Skosan.
Thank you, Chair. Good morning. Chair, a problem starts when a member has valid reasons to say whatever they want to say and to raise any concerns they have. But what cannot be happening and what cannot be allowed is another member invalidating the concerns of another member. Honorable Skosana raised his consent. You addressed the concerns and you paved the way forward. Member of the DA takes the mic, invalidates that which you have already ruled on, and the feelings and concerns of Skosana as well, which is wrong. That's why you should have called him. I'm done with this matter. There's no need for you to speak, because he felt that he's too important. He must do it even when you have done it. That is why we are going to have a degeneration, because there's no member that can come here and be invalidated by another member. And that's not going to happen, and we are not going to allow it. So please, Chair, when a member has spoken and you have paved the way forward about that, it ends there. No other member must feel very important that they must say anything besides that. We want to keep quiet. Every time you say, members, I'm pleading with you, let's no longer say anything. We all kept quiet. But he kept on coming. And you don't say to him, please stop. He must stop doing that. He must stop invalidating us. He's not important in this meeting more than anyone else. Thank you.
Thank you, Honorable Beasley.
Yeah, thanks, Chair. I just think what I saw transpire is it's very disappointing, and I think we just need to show respect towards each other. We're human beings. We might disagree with each other, but let's respect each other. We've been voted here by certain constituencies. By insulting the other people, we're insulting their constituencies. So let's just treat people with respect. I was taught manners growing up, and I think some people in this room need to learn manners, and it's just a matter of common courtesy and common respect, and I'll put that forward. And South Africans deserve better than what's just transpired. We're better than this. We're here to lead this country, not to further divide it. Thank you, Chair.
Thank you, Honorable Beasley. Honorable Skosana.
Yeah, no, thank you very much, Honorable Chair. Yeah, Chair, I think you handled the concern that was raised earlier by Honorable Skosana very well in terms of the processes and procedures of Parliament. And we commend you for that. Yeah, well, I think Honorable Beck, I think he's got a weakness. I think this thing is a weakness because he's not doing it for the second time, that when he's not happy with something, he would just come in. So it's a very serious weakness that he need to work on it. I think it was uncalled for him to do that. But also, I think it's also wrong and unparliamentary for Honorable Skosana to call him a racist. In terms of Rule 84, that's an unparliamentary language. You can call the DA as an organization a racist organization. That will be a point of debate. And that will be his views. But to call a specific member a racist, that is unparliamentary. Thanks, Chair.
Okay, members, I think Honorable Beasley and Honorable Skosana and Honorable Mende have brought us to the close of the issue, please. Okay? Let us recognize what they've said. Let us recognize what they said and accept that we are going to treat one another with the necessary decorum and respect for the people that are watching this meeting from home. May I please ask colleagues, however much we feel about what a member might be saying and however much we disagree, we leave that member to have the floor until they are done. There is enough time and too few of us here today to worry about not getting a chance to speak. We are all going to get a chance to speak, members. Please, thank you so much. I really appreciate your cooperation. Members, thank you. So shall we go back to the issues on the agenda? So the first one is a matter of the Road Accident Fund. And I'm going to preface my comments in this way. And we've distributed the memo to the members, but I have nonetheless asked the committee secretariat to put it up. And I'm going to preface my comments in this way. The committee generally gets any number of whistleblower and public concerns about honorable members and colleagues, please. WhatsApp each other. We get a number of concerns, whistleblowings and so on, and at least I feel an obligation to follow up on all of them if we can. There is an anomaly in that reality that we deal with. The volume of communication, either from members of the public, the staff, or other stakeholders of the Road Accident Fund, is I can only term as a flood. I have had to ask that we rearrange the way the committee secretariat works so that we may have somebody who just helps us with those matters. They are too many. They are too concerning. They come at such a frequency that even this memo that we are presenting, when I consider what we received on Thursday, Friday, the weekend, and this morning, it is already becoming obsolete. That is the volume of concerns that we get. Now, the committee has a vast amount of work that it has to do. We still need to complete our conversation with Dinel. There are new issues that have emerged at PRASA, for an example, etc., etc. I can't go through the whole list, but our work is voluminous. We can't have the same institution coming here every month to the detriment of oversight on other institutions. So I'm going to put it up front so the members know where I am going with this. We will need to collect as much of this information at a certain point, compile it, synthesize it, make it available to the members, and then we have a committee inquiry where we set aside a specific amount of time, we deal with the issues, we compile a report with recommendations for the executive, for parliament, etc., and we know that we've dealt with the issues. Otherwise, we're going to have the road accident fund going up and down to parliament all the time to deal with things that we get, and I don't think that is an efficient use of our time. So that is the first thing. The second thing I want to say is that there are so many points of dispute, and people that are able to come to parliament, who was here when something happened, who was not here when something happened, and particular instances, several instances where I have felt and I've raised in the committee that the level of disclosure and the truthfulness of the information is lacking. So one of the things an inquiry will assist us is that we will then be able, if necessary, to subpoena people, whether they're still with the institution or not, whether they're still with the government or not, to come and present themselves and account to the committee, to parliament, and to South Africans in general, so that we can get to the bottom of what the issues are at the Road Accident Fund. So that is the second thing that I think is important. That's where I'm going with this. And part of what we need to do, at least at a high level, is to agree, in the event that we agree to part one, is to agree what then would be the terms of reference and the scope. The third thing that I want to say is that the mandate of our committee is specific. We are not the portfolio committee on transport, under which the Road Accident Fund falls. But we are tasked with ensuring accountability in terms of what we believe is maladministration, financial mismanagement, misallocation or use of public resources, and so on. And the matters that I have placed before the committee in this memorandum, in the end, lead to all of that, to all of those. The seeds of maladministration, actual maladministration, the inappropriate use of public funds, etc., or waste. Because the members have the memorandum before them, I am not going to read it. I am, however, as the person and I'm grateful for the help that I received from the committee secretariat in pulling this together, ultimately it's my signature on it, and I must own it and explain the memorandum to everyone. And do this recognizing that there continues to be much public debate and appearance in other portfolio committees. The first thing that I've placed before the committee in the memo is my interpretation and implication of the organogram and the vacancies, and therefore the lines of authority that arise as a result, and therefore the impact that it has on public funds as a consequence. And I've made several examples, and I will not do this in sequence. For example, the committee has raised previously the issue of people who are facing disciplinary charges in one place, go to another institution, get a job, and life continues as usual. The committee has continually asked about the vetting of officials. In almost every meeting, the committee asks. You have all been here when we've asked the Road Accident Fund about the vetting of officials in general and also the vetting of particular individuals. And we've received conflicting reports. On the 26th or 16th or 19th of October in 2024, we were here, the chief executive of the Road Accident Fund and the chairperson, they were sitting on this side. They said the chief executive has been vetted. They came here in March this year. They said the chief executive has not been vetted. They forgot what they told us in October. That's an anomaly. The second instance, we had a back and forth about the role of chief investment officer. I have explained in the memo that first of all, the Road Accident Fund is not a PIC. Chief investment officers do long-term asset allocation or capital allocation. That's not the role of the Road Accident Fund. It so happens that the person who's acting in that role is a person who falls under a concern the committee has raised about the vetting of people and people escaping discipline. Members were here in March when I asked, where is this money invested? The chief executive of the Road Accident Fund said, we can't tell you where the money is invested because there are people who are looking for it. If the PIC were to appear here and say to the members, we can't tell you where the money is, I think justifiably the members would be outraged. But that answer was given to this committee. So incidents like that make anyone ask, hang on, what is really going on here? Why are we getting these answers and so on? I will make two further points on this organogram. There is no chief claims officer. There is no head of claims operations, as we can see. The people in the regions, according to some of the whistleblower accounts we have, are acting. So the entire claims ecosystem is gutted. Then there is no head of legal. There hasn't been a head of legal for 2.5 years. In fact, by the Road Accident Fund's own letter to me on Friday, they last advertised for that role and the chief claims officer in 2023. They did nothing for the rest of the second half of 2023 and nothing in 2024 and nothing for the first half of 2025. That cannot be correct. That has got a serious impact because the Road Accident Fund works with litigation which in the end costs taxpayers money. Over and above that, within a short period of time, I've said in the committee, that's what I mean by obsolete. I asked the Road Accident Fund, how many legal staff have you lost over the last 3 years? They have lost 28. And there's no head of legal. And the Road Accident Fund is not even able to show up in court to say we are defending a matter. And where someone should be awarded 500,000 rand, they might get away with 6 million. Because there's no one to defend the matter. And when the Road Accident Fund shows up to now try and overturn, the court says you should have been here, you were not here, you are still not ready. Punitive costs over and above, which taxpayers pay. I'm going to leave it here because I'll be repeating the memo. All I'm saying is that when you objectively look at the organogram, and you look at the vacancies and the financial impact, you come to the conclusion that someone must account for this state of affairs. It cannot be okay because we have to be consistent as a committee. If we ask other institutions these questions about acting people and the impact, we have to ask everyone about these matters. So that is the first thing and the issues that attend to it. Denzel, can we move on to the second topic then? We were here as members of the committee, and I've dealt with all of those issues, Denzel. So we were here as members of the committee the other time. We've dealt with the inaccurate and false information and just not being given information. I will make just 2 examples here. We had to adjourn this committee meeting to obtain information that we had asked for as long ago as the 16th of November last year, about law firms that the Road Accident Fund pays to handle its matters. They didn't give it to us. They said in October they don't have it. I sent a letter on the 16th of November, asked for it. They didn't give it. We invited them to provide it in March. They didn't provide it. They then came back again in May. And then eventually we said, please do it now. In that disclosure, there were two overall material omissions. The first is the total amount that is given, that is paid to the law firms. It was inaccurate in two respects. One, how much has been allocated and paid to some of those law firms. There were also law firms that were not even on the list, like Mashiane Moodley. They were not even on the list, but they were paid by the Road Accident Fund. That introduces a difficulty for the committee in that we are now not certain about the quality and truthfulness of the information that is provided to the committee. So can we move on to the next one? So let's move to the next topic. Then there are further allegations about some of the contracts that the Road Accident Fund has. And one of the things I do, members, is that when somebody makes an allegation, I do write to the institution to ask for their view and evidence thereof. I can tell you those two media services contracts exist. The members will get them. They exist. They arrived on Friday evening. I just didn't have enough time to synthesize everything. They are signed by an executive who is not of that function that should sign them, because that person is acting. The signatures do not look the same, even though they're signatures of the same person. The deliverables are unclear. And I'm speaking as somebody who's concluded similar contracts in the past in my professional career. They are supposed to last 5 years. The rate of expenditure is such that one of those is nearly depleted already, but it's got 2 more years to run. Now, some of the questions we might have to ask is, so which one is your signature here? Because they don't look the same. So what do we deal with this? There's another issue which is the result of a whistleblowing, which pertains to, I think it's a contract for office furniture. I think it's under number 4. It was flagged, and the committee has been sent the report to say this is what specifically happened in this instance. Please address this concern, because information was taken from another bidder and allocated to another. I asked for the relevant contract. You know what? The Road Accident Fund confirmed last Friday that the contract is active. So we have to ask, why was nothing done? I can move to this one because this one has been in the papers, the Moana properties. The whistleblowing is so detailed. The person says, I'm the person who had to change what had already been decided. Here are my emails. Here are minutes of meetings. They wrote to me yesterday to say, please get the police to protect me. I am feeling unsafe. They wrote to me. They wrote to the minister to ask for protection. So again, colleagues, these are matters I don't think we can keep every time there's a whistleblowing, we ask somebody to come here. And I'm just talking about the matters that we have received. The last point is what I will call matters relating to the rule of law. So once during the next day or two, and I'll work very hard to make sure that we synthesize all of this information, we've dealt with the Auditor General issue here. I am not quibbling with the issue of accounting standards. But in South Africa, we have a certain way in which state institutions take up matters that they are not happy with. First of all, I asked, okay, please send to the committee the internal legal advice that you obtained before proceeding to court on the matter. One sentence answer. There was no legal advice sought, and therefore those memos do not exist. We have spent, as taxpayers, nearly 20 million on that case. I think it's the business of the committee to follow up on that. The second point is, and I've made the example in the memo, other institutions find themselves in similar situations all the time. I've made the example about Eskom and NERSA's decisions. Eskom does not implement the new tariff structure because they disagree with NERSA. They say we will take you to court. We will do what you want for now, but we'll ask the court to claw back what you did not give us once they agree with us. As it happens, in the previous round, the court actually agreed with ESCOM, and ESCOM was allowed to claw back. The only thing I'm appealing to members on here is this. We must think carefully about the door that we are opening, where if one state institution disagrees with the rule of an empowered state institution like the Auditor General, they can ignore it. The point here I want to say again is not whether the Road Accident Fund can go to court to challenge the view of the Auditor General. They can. What we must be careful not to allow is a situation where, because we have to be consistent, a Auditor General feels financial statements are not up to scratch. You made a loss. The institution says we feel we made a profit, and we are going to continue to present that here. I think the committee would be unhappy were that to happen. The final point that let's just complete the thing, because then I need to give the members an opportunity to comment. So what I'm saying is that the matters are too numerous. They relate to contracts, use of money, maladministration, and so on. And the proposal is this. We determine the terms of reference of such an inquiry. It has to relate to maladministration and so on. So it's not our job to deal with policy matters broadly, because that's a portfolio committee. There are lots of allegations and counter-allegations. Everybody involved needs to get an opportunity to present their side of the story before the committee. We need to give everyone an opportunity to do so under oath. And having considered all written evidence and testimony, we then write our report. We reach our conclusions, we write our report, and we table it before the House. And those recommendations can then be implemented. The timetable proposes the following, because that also takes account of the timetable of Parliament. One, that as soon as the members have agreed broadly on the terms of reference, the committee secretariat writes them up. On there, is it the 30th that we can come back? The 1st of July. On the 1st of July, we do the same exercise. We look at, they get sent beforehand, we look at the terms of reference as proposed, and we finalize them. Then we use the period between July and the time that we come back from recess to prepare and also invite the various parties, because within those terms of reference, we'll also say who needs to come. And then when people come here and they testify, we have a consideration of all the evidence they place on the table, and then we complete our work. That will also give the committee space to deal with all these other institutions we see in the papers, and we get an ulcer, because there are also things that are bad that are happening there. It gives us a space to complete our work in respect of other things. So that is the way forward that I propose. The last point I want to make is the Ministry and the Road Accident Fund have sent us an enormous volume of documents, with a document that sets out, it's got annexures and so on. During the course of this week, the committee secretariat and myself will synthesize all of this, prepare a detailed covering memo, and share all of that information with the members. The only information that will be redacted is critical whistleblower information, such as phone numbers and their names, because people have attached their names. Some of them have said, you can call us, but I have got this concern. So that's what we'll do, but the committee members will also get enough time to consider all of this information. So nothing will be hidden, basically, except information that we just generally want to protect. And then after that, when we come back on the 1st of July, the members would have seen the same information that I have seen. And we can finalize it. We can comment on the terms of reference, and we can finalize the terms of reference. And then we proceed on that basis. Members, let me stand down. But that's what I want to propose we do. Now, you've all had regard for the memo, so I am going to ask for comments. We'll start this way because the first hand has come from that side, and we will come this way. Honorable Atkinson.
Thank you very much, Chair. And I fully concur with everything that you said. I just want to add that this is actually a deeply concerning situation, because the kind of amounts of money we're talking about could actually dwarf anything else that this committee has dealt with. It could make SAA look like a tea party by the amounts of money that are involved, and the potential liability that has been created for the state by the fact that claims have been rejected by the Road Accident Fund based on their legal board minutes and sent back to the people that sent them. The problem is that those claims that have been lodged with the Road Accident Fund, even though the Road Accident Fund might believe that they don't meet the criteria, actually might necessarily meet that criteria in law and could actually be valid claims. So what could be resulting from the illegal actions, the illegal board minute, is that a liability is being created on the state that at the moment we can't quantify, but it could run into the tens of billions of rand. Not only that, but we have also seen through the issue of some of the contracts and various other aspects, the amounts of money that the Road Accident Fund gets in from the fuel levy. We're talking about considerable amounts of money, and that as you're saying, there are large question marks over how some of that money, where it sits, because the CEO wasn't keen to tell us exactly where that money sits, which, I mean, as a public entity, he does need to disclose that. So what I'm saying is I think there's a great interest in the public, because if you recall in the last budget, the one increase that the finance minister did was to increase the fuel levy. And the fuel levy is exactly what funds this road accident fund. And I believe if we can get to the bottom of the corruption and the waste of money, that increase in the fuel levy might not even have been necessary. So in essence, the public of South Africa are paying for corruption and maladministration at the Road Accident Fund through an increase in the fuel levy which they're experiencing. So this actually touches the pockets of every South African. So I believe it's critical that we actually get to the bottom of it. With regards to the issues of the fact that the officials at the Road Accident Fund have been less than open and honest with this committee, another factor has been drawn to my attention at the last meeting. The acting CEO of the fund basically said that 3% of all claims were default judgments. By going through court orders and the court papers since January this year, that figure's closer to 87%. The Road Accident Fund doesn't have the IT sufficient to be able to differentiate between a court judgment and an agreement. So they actually don't really know themselves. But if you look at the court paper, if you look at the records of all the judgments that have been given, 87% are default judgments. So the variation between what we've been told and what the reality is vast. I mean, one could forgive it if he said 20% and was actually 30%. But between 3% and 87% is actually a shocking misrepresentation of the situation that we face with. The other thing that I'd like to ask for is that when it comes to the terms of reference, I'd like us to look at the employment of Mr. Collins Letswalo and whether that actually is a valid employment. Because the reality is that we know that for 7 years he's operated without security clearance, which completely goes against the terms of his contract. And what we've been told is that he wouldn't go for the polygraph test. So in essence, he was mala fides. He was in bad faith. And my understanding is that if you're in bad faith, you invalidate your terms of your contract. So the fact that he was binding the Road Accident Fund in these legal actions against the Auditor General, he may not actually have had the legal standing to be able to do that, because if he wasn't a properly appointed official, if he didn't meet the criteria for his appointment, it raises huge questions as to whether he could actually even act on behalf of the fund itself. So I would like that to be one of the terms of reference, is to look specifically at Mr. Collins Letswalo's situation with regards to his security clearance or lack thereof, and where that leaves the fund legally, and whether he actually really ever was legally appointed. Because of the fact that, as I said, there was a mala fides action on his behalf not to get the security clearance done. Chair, I go with everything that you said, that there has been a discrepancy between what we've been told and what the facts are of the information that we've been getting back from from the whistleblowers as well. So I think it's a critical factor that we take the bull by the horns here, that we do set up a committee inquiry into it to get to the bottom of what the situation is, and also to try and get a handle of the potential liability that might be out there as well. Because, we're talking about the fact that it could be tens of billions of rand. I think the state has got a huge problem here. And I don't think we can actually ignore it any longer. I think as a committee, we are required to come to the defense of the people of South Africa, because this is really what it is, and the complete waste of their money through corruption and maladministration. Thank you.
Thank you. Yeah, we're just going this way. If a member wants to pass up the opportunity, you can say.
Yeah, thanks, Chair. So I fully agree. I think the liability at the RAF it's massive, and that's why they keep fighting the Auditor General, because they don't want the true state of their accounts. And I think you've been very kind, saying we've been lied to, Chair. We've been lied to by the board and by the CEO, and I think that they've crossed a line when it comes to that. But including in the terms of reference, Chair, I would also like to include is that we've got to celebrate and honour competent people in these organizations who put their hand up. And my concern is that the RAF has used state money to bully competent employees. And I think most of us agree bullies are the worst in society, because they're just destroying lives, Chair. And I think I would like to have included in the terms of reference that particular clause as people who've been dismissed, and the RAF have used state resources to prevent these people coming back, and actually destroyed lives of competent, decent human beings. And I think that is the lowest form of power, when one can actually use state resources to stamp on somebody and destroy their lives. Thank you, Chair.
Morning, Chairperson. Morning, my colleagues, and everyone present here. Chairperson, I wish to express grave concern regarding the conduct and governance of the Road Accident Fund, particularly under the current leadership. There are serious allegations of abuse of power, financial mismanagement, disregard for legal processes, and undermining court procedures. Just looking at the maladministration, the media spread, the Clark projects, and many more. The inhuman behavior of the CEO against the shop stewards and persons that are working for the RAF. It is absolutely unacceptable. These actions threaten the integrity of the fund and its ability to deliver justice and compensation to road accident victims. I'm therefore proposing that this committee urgently considers launching a full inquiry with the committee inquiry, Chair. I think we have no other choice. And let's see from there. It is just unbelievable. Thank you.
Yeah, no, thank you very much, Honorable Chair, and good morning to everyone in the meeting. Yeah, no, Chair, we support your suggestion to have a full inquiry into matters of the RAF. Because I think we've said with the board and executives, with the deputy minister, I think twice, if I'm not mistaken. In some instances, the board and the executives with the CEO, they would agree on matters, but in other instances they would contradict each other. And in our last meeting, it would also appear that the board was not sure of what they are doing in terms of handling their matters, including handling the matter of the suspended CEO and so forth. I also followed their interaction, the interaction of the board with the Transport Portfolio Committee and the interaction between the Transport Portfolio Committee and the suspended CEO. So there are quite a number of grey areas in terms of the operation of that particular entity. There are quite a number of contradictions and so forth. So I think it would really assist to have an inquiry, because the benefits of having an inquiry is that we are able to have a conversation with other people outside the board and the executives, maybe people who are in the employment of the RAF, maybe who are below the executive levels, who've got information that they would want to share with us. Would also be able to have a conversation with external stakeholders, maybe who are doing business with RAF, or who had done business with RAF at some point, or any other person who would have any information that relates to RAF. So it will really broaden our understanding as the committee to hear all different sides of the story in relation to this particular entity. And it will also help, because if we do an inquiry, everyone who will be speaking under oath, unlike now when we just invite them for a committee conversation. But if it's an inquiry, everybody will know that I'm speaking under oath. So I must make sure that what I'm telling the committee is truth and nothing else but the truth. And I think you have reminded us of a number of inconsistencies where they would say something and then next time they would come and change it and all that. So I think if it's an inquiry, everybody will make sure that whatever he or she says before the committee, he or she say that under oath. Amongst, I think, another issue that there's a quite the volume of these documents that we have is quite a lot. It's not something that we can just sit in a meeting and take a decision. We may arrive at a wrong decision, but if we've got an inquiry, we'll have enough time to read the documents and then interact with the relevant people, so that at the end of the day, we are able to take an informed decision and make proper recommendations to the National Assembly. For instance, I was looking at one case, just because it's a shorter case in my view, the issue of Mr. Victor Songelwa, who is the general manager for finance, who received a letter from lawyers that his contract is being terminated before time. His contract was supposed to end by end of September. So he received letter from lawyers, not from his supervisor within the employment. He received a letter from lawyers. It's a person who's not been charged for anything, has not undergone any disciplinary hearing. But they are saying, no, we are terminating your contract 5 months earlier. However, we're going to pay you. So we are not going to suffer because of this, because we are going to pay you up until the end of September. But then the question that if you pay this person sitting at home for 5 months, is that not a fruitless and wasteful expenditure? And who will be playing the role that this particular person was playing in the institution? Because this person is sitting at home for 5 months, it means somebody else must come in and act and also be given an acting allowance. So it means the organization will be incurring fruitless and wasteful expenditure without clear reasons as to why is that done. So I think these are some of the things that would, as the committee, I think would be interested to get more information from him, but also from the institution, to say how can the institution take a decision like this, especially when the person has not been subjected to any disciplinary hearing, has not been charged with anything. I think it was going to be a different case if this person was charged for a certain misconduct, has attended a disciplinary hearing, and therefore they arrive at that particular decision to say, we don't think as an institution we can be able to work further with you, so we decide that let's terminate your contract. But here it's a person who, according to him, well, we have not heard the side of the story from RAF, but according to him, he has not been charged with anything, he has not attended any disciplinary hearing, but he just received a letter from lawyers. I mean, when lawyers are involved, it means there's a dispute. But now, this person, there are supervisors who are supervising him, but they get a letter from lawyers that says, no, we're ending your contract within 3 days, but we are going to pay you up until the end of September. No, it's not about him being paid, but it's about the resources of the institution, that somebody must go and sit at home and get paid for nothing. and then somebody must then come in and act and also get paid. It's a serious problem. So we would like to get the side of the story from the RAF, but also get more information from him. So these are some of the things. There are quite a number of cases I think that we do have, but these are some of the things that will make it necessary for us to have that kind of a conversation and inquiry to get more details on issues like this. So we fully support that proposal, Honorable Chair. Thank you very much.
Thank you very much. I'm going to come to you, Honorable Nondenja. And this is one of the correspondences I will share with the committee. There are two. But one relates to Mr. Songelwa. There was actually a labor relations dispute between Mr. Songelwa and the RAF. He won at every stage. So the litigation is now complete. The RAF has been instructed to reinstate him. Rather than do that, they've told him to sit at home. And so there is a judgment, actually, that we can furnish the committee. The second case I received on Friday. It relates to a I can mention it because it's in the public domain. There's a court case. The matter has gone all the way to the Labour Appeal Court. Ms. Plope from KZN was disciplined for asking whether she can ask a question in a meeting. She won she was dismissed, won at the bargaining council or at the CCMA. The RAF appealed to the Labour Court. The Labour Court ruled in her favor. They then appealed to the Labour Appeal Court. And the Labour Appeal Court ruled in her favor and levied punitive costs against the Road Accident Fund. She attempted to come to work 3 times. On each occasion, she was turned away. She must now go back to court to get a contempt order so they can reinstate her. She says in her letter that she has been hospitalized, she's on chronic medication, she's got suicidal thoughts. I can go on. Now, we can't ignore this because we've also got to ask, is this an efficient use of state funds? Is this the only case? And when you consider that the institution has lost 28 lawyers, who is advising you on these matters that then proceed to cost money? So one of the things the members will see in the letter, I've asked them, how much have you spent in the last 3 years on labor relations costs? It's close to 50 million that they've spent. So I was just correcting that fact, but also saying that's an area that I think the committee needs to inquire into, because you don't have a head of HR, you don't have a head of legal, you've lost 28 lawyers, you are litigating. So who makes the decision? And there's no regional head. So who decides? So these are the questions that I think an inquiry would help us to settle. But factually, there was a dispute. It went all the way up the chain and the person prevailed. They just don't want him at work, so he's now sitting at home getting paid. And his salary, as I understand, is well over 1.5 million per annum. Anyway, Honorable Nontenja, sorry.
Thank you, Chair, and good morning, colleagues and everyone. Chairperson, let me start by thanking you for compiling the memo for us. You really made our work a lot easier. Thank you. Chair, this institution seems to be a law unto itself. It's taken to court, there's a judgment, and it just ignores all that. So we really support your view that there must be an inquiry. And the fact that they are, beside contradicting each other, they are not forthcoming with information that's requested. And if you look at what comes from the whistleblowers and what they can give, there's a huge disparity there. I would request that the inquiry must include a forensic audit, because from where I'm sitting, I don't think the HSA also has everything that it should have. Besides, we know that when they audit, they would take samples. They don't really go deep. But this institution is calling for a forensic audit, because they're hiding something, and it's something huge. And they are just doing as they please. I just hope that having inquiry will give us a way of getting deep to the roots of what is really happening there. It's amazing how they get away with everything, and it makes one ask questions as to when the AG's office sees this year in and year out, and they continue to use their preferred standards, not what is approved in the country. They take their own route, they do as they please. It's really something that calls for action, and the sooner the better. Thank you, Chair.
Honorable Skosana.
Thank you, Chair. The issue of RAF, it's touching a nerve of many people in this country, I must say. There's a lot of interest in this matter. For a simple reason, money. Nothing else, money. When the CEO was sitting here telling us that he saved just over 20 billion rand, some of us applauded him to say he has done well. Some might not have done that for whatever reason. But the issue and the facts is that the CEO and his team saved this country over 20 billion rand. No one can deny that. It was factually proven here in this committee. With all the things they have, I've seen recently a circus from the minister, deputy minister, to the board, to the executive itself, to the management itself. My concerns here, Chair, I'm seeing the names of companies here, but there's other names which are not here on this report. Perhaps the Chair will exactly tell us why these other companies are not here. I'm talking about these lawyers' firms, these attorneys' firms here. Some of them are not here. And perhaps for a reason, that's why perhaps you did not pen them down here. Because I'm seeing few companies here. And I guess even the name of these media companies has to be here. You know, what do you call it, mixed 360 or so. These media companies which were awarded 1 billion rand tender for media. There's two companies, I think it's Giengo, but they should be here. The names should be in here as well. People should not guess who are those companies. Whether they look dodgy if you check the directors in those companies, but their names should be here. Those names as well of Bowmans and Vexmen, they should be here. We must know exactly how much have they benefited from RAF. Nothing must be hidden. We must know exactly who is milking this institution. Not necessarily milking per se, perhaps they deserve to be paid all the money which they are claiming here. But we need to know them. Nothing should be hidden here. Everything must be here, because we are saying people should really account here. The issue as well, because as I said, Chair, I'm seeing Malachi, and again, you know, Mponyana, Litwaba, and whoever these companies are. But I must say to you, Chair, where I'm sitting. As I said earlier, these big firms are not here. And I don't know what was the reason, Chair, why these big firms' names are not mentioned here. But at a later stage, when the Chair is wrapping up, perhaps you will give us the reason
I will
why.
respond substantively. Thanks.
On that, yes. And this issue of, there's an issue which has been going on, you know, about the Audit General and RAF. The IPSA issue, the GRAP issue, and the issue of courts. I want to reiterate once again in this COCO committee. Whether the court has rejected your appeal, you have the right to go to the highest court of the land, the Constitutional Court. And I said it here when the Deputy Minister was arguing, telling me that he started here, I don't know how long, you know, he's got experience, you know, maybe we don't have experience because it's a 1 year. And I argued to say, you might have a service of 10 years, but no experience. You might sit here for the last 3 administration, but that does not mean that you've got experience. You might have been sitting here doing nothing. Now, this issue should not be like now we want to dictate when somebody has to stop going to court. If he goes to the Constitutional Court and he fails there, so fine, no problem, the matter is closed, whether we like it or not. But it can't be the matter end up at the Supreme Court of Appeal. Then is the end of the story. If the team, the top management, not necessarily the CEO, because he's not operating there alone, can save 20 plus billion, then we are here to debate about 50 million. For me, that's being indigenous for me. For me, I'm saying here, to say, irrespective of what other people are thinking about this issue of RAF, the issue here is not about that. It's more about lawyers here and doctors and these big firms. The discoveries of this world and others. It's a fact. Now, Chair, can you protect me once again? Thank you. Before I continue, because I'm getting offended, Chair.